Okay, sir.
The Code of Criminal Procedure is another one, which is very popularly known as Criminal Procedure Code. It was since 1973, it is helping us. It has got 37 chapters with 484 sections. It all tells about the various trials, various appeals, and how the case will be revised. Its revisions are explained there. The investigating officers and the duties of police in the investigations are prescribed, and the mechanism of punishment is also described under this Criminal Procedure Code. Then the Indian Evidence Act of 1872, which has got 11 chapters with 167 sections. It is explaining all aspects of evidence and the judicial proceedings at a large. So with these pillars, the judiciary works, its functioning takes place. Whenever the offense or crime is taking place, the inquiry will be made. The inquiry will be made by various authorities. Inquest is one of that. Inquest is nothing but the legal inquiry into the circumstances and cause of death of sudden, suspicious, and unnatural kind. So whenever this kind of sudden, unnatural, suspicious death is taking place, the inquest will be conducted. So there are different kinds of inquest. It all depends on who it is conducting. It is either conducted or initiated by the police as per section 174 of the Criminal Procedure Code. It is called as police inquest, or as per section 176 of the Criminal Procedure Code, magistrate initiating the inquest, and it's the magistrate inquest. Coroner inquest is another one, and the medical examiner system is the fourth kind or fourth type of inquest. So police inquest is very common in India. Who will conduct this inquiry? It is the police in charge. The Criminal Procedure Code explains that it is the right or the power given to the state to decide who this officer will be. In many of the books, it is mentioned head constable will conduct, but it is depending on the powers given to the police officers by the state. Here it is in the month of January 2006. As per the Maharashtra government, who has actually offered the rights to the police nayak and the police officers above the rank of police nayaks for conducting the inquest. You can see this Criminal Procedure Code and police nayak and above the rank. So it is from the government of Maharashtra who has given this right to perform under these various sections, including 324 injuries because of the dangerous weapon. Also, he can make an inquiry, an inquest in that case. In addition to these, various other acts and laws are given and their sections under which the police nayak can conduct an inquiry. Again, in this situation, he can conduct the inquiry and make an inquest in sudden deaths also, excluding the dowry death. So as per the Maharashtra government rule of 2006, the police nayak and above can conduct the inquiry. So for the information, for your additional information, let me tell you what the Taluka police station and the district police station usually have got the various police officers. At the base, you can see the constable, and here lies the police nayak, then the head constable, assistant police sub-inspector, police sub-inspector, assistant police inspector, and the police inspector. So after the appointment and within the 12 years or more than that, the constable is getting the promotion of police nayak, and he can be a investigating officer as per that law. See, some of the books were mentioning this head constable, but it is the police nayak for Maharashtra who can conduct an inquest. So when he will conduct and how he will conduct, he will approach the scene of crime or the site of the offense and get the information as much as possible in presence of 2 to 3 respectable individuals of that locality called panchas, and make an panchnama, which is also called as inquest report. And that inquest report will be signed by those panchas along with the investigating officers. This all will be done after the information. That is what we are calling as first information report. After getting that information, the police officer will be reaching there. And then the body, if the death has occurred, and they have got some suspicion, the body will be sent for medical legal autopsy. If they are convinced with the panchas and the local individuals there, along with the investigating officer himself, they can dispose of the body, provided the suspicion and the foul play will be ruled out. But in cases of suspicious deaths, the body has to be sent for medical legal autopsy. The magistrate inquest is another one. In India, this is the second next common inquest, usually being done by the executive magistrate. These are the administrative officers having the judicial, quasi-judicial kind of powers there, being administration main task allotted to them, like collectors, deputy collectors, the subdivisional magistrate SDM, the tahsildars, naib tahsildar. These all are the executive magistrate, and they can also sometimes perform the inquest other than the situations in which the police are performing. This is usually being started with noting down all the facts. In the situations where the police is unable to conduct the inquiry, in cases like dowry death. What is this dowry death? The death of a married woman usually taking place because of the harassment, brutality, and for the demand of the dowry within the 7 years of the marriage. And if the lady is dying within 7 years with such history, the inquest will be conducted by the magistrate. Also in cases of death in prisons and in police custodies, also in a death during police firings or riot, because being the police as a one party, they can't be the investigating authority in such case, and magistrate will be performing the inquest there. Exhumation is also ordered by the magistrate. This is nothing but the legal digging out of the already buried body. So what is this exhumation? How it can be performed? The magistrate is ordering it. Magistrate himself will be present along with the police officers, along with the relatives who are actually claiming for. This usually being done early in the morning so that the time taken will be more, and they will be reaching to the graveyard and identifying, the relatives will be identifying the grave. Then also the in charge of that graveyard will look at to the record, and then the grave will be identified. The digging will be started. Then they will reach to the body, will be seen, then will be taken to the mortuary for medical legal autopsy. So this is exhumation, usually being done in cases of any suspicious foul play, any allegations for the identification purpose, or in which the second autopsy is demanded by the relatives. Coroner inquest is another one. This is usually done by the coroner. Trial rather than inquiry is usually conducted. Whenever the coroner is getting information about the suspicious and sudden death, which has got some reason, intention behind, then he will call an inquiry by summoning the related individuals in a coroner's court, and the inquiry will be conducted. And this is what called as coroner inquest. Initially, it was there in the Mumbai and Kolkata, but abolished in India since 1999. So coroner inquest was there in India, but now it's abolished. Medical examiner system is the another type of very superior and followed in Western countries, because the forensic pathologist led the investigating team by reaching the scene of crime, by seeing the evidences there, seeing the position of the dead body, collecting as much as trace evidences from the site, and then taking the body for medical legal autopsy. This all happens usually in cases of sudden unnatural deaths. And as I told you, USA is a place where this medical examiner system is being conducted. It is superior to all the three because the autopsy surgeon himself is reaching there and collecting as much as trace evidences he can, and there are very less chances to miss the biological samples at the scene of crime or even other trace samples also. So with these types of inquiries, the case will be filed in a court of law and then trial begins. So at this juncture, you should know the various types of courts available in India. In India, there are civil as well as criminal courts. Civil courts entertains or trials the cases related with disputes between two parties. Usually one is affected, and these disputes are about land, property, compensation. The criminal courts trials the cases related to crimes, offense, in which the one party is the state itself and other party is the sufferer, the victim side. Why this is happening? Because the person who has committed a crime disturbs the harmony of the society, damages the peace, damages the individuals, and that's why the state takes the part to lead. And because of this condition, the state becomes the another party. In India, the apex court is the Supreme Court, which is situated in the capital of our nation, Delhi. It is an appellate court. It can award any sentence prescribed by the law, including death penalty. It is presided by the Chief Justice and appointed by the President of India. Next is the High Court. It is the apex court of the state. And you know, there are almost 28 states with 8 union territories in India, but having 25 high courts only. Why this is happening? Because not every state is having the high court, but almost every state is there. Like Mumbai, we have got a high court situated there in the Mumbai, which is also the high court for the Goa state, which is also the high court for the Union Territory Daman Diu. And its additional benches are there in Maharashtra at Nagpur and Aurangabad. These benches are meant for the convenience of the people and to speed up the inquiry. Then every state like Karnataka is also having its high court situated in Bangalore. Not necessarily it is situated at the capital of the state. See, at the Madhya Pradesh, it is situated at the Jabalpur. At the Uttar Pradesh, instead of Lucknow capital, it is situated at the Allahabad. For the Chhattisgarh, the High Court is situated in the Bilaspur. For the Rajasthan, the High Court, instead of Jaipur as a capital, it is situated at Udaipur. So capital is not necessarily the station for the High Court. These are certain situations. Even Union territories also has got their High Courts. Delhi High Court is the examples there. And there may be sometimes one High Court taking all the jurisdiction cover of the nearby states, like Guwahati High Court is taking few of the northern east states under its jurisdiction. So being the apex court of the state, it is looking after all matters and is appellate court again. It again award any sort of sentences, including death penalty. It is presided by the Chief Justice of the state and again appointed by the President of India. Whoever is not satisfied at the judgment of this High Court can approach to the Supreme Court. Next comes the session courts. Usually these are situated at every district headquarters, and they have got the additional assistant session courts also in their districts, and their additional benches are also there in the districts so that they can speed up the inquiry. It has got a power to pass any of the sentence, including the death penalty, but it has to get it approved from the High Court. Whoever is not satisfied with the decision here in this session court can approach to the High Court. The magistrate courts are the next one. As I told you, there are either executive magistrates or the judicial magistrate. Judicial magistrate has got a educational background of law, while executive magistrate not necessarily having the background of law. They are actually the administrative officers like district collector, sub-collector, tahsildars. The judicial magistrates are of chief metropolitan or judicial magistrate type, metropolitan or judicial magistrate of first class, metropolitan or judicial magistrate of second class type. And accordingly, they will preside over the different courts. There are also some special courts, like in 1984, Bhopal tragedy was taken place, which causes thousands of casualties. To look after their rights, the compensation, to solve their disputes, the special magistrate court was set up in the Madhya Pradesh, and that was a special kind of magistrate court. And also to look after the juvenile cases. WHO says that whoever has not attained the age of 18 years has not got an understanding of that of adult type, and if he committed a crime, may not be punished, and that's why their trials will be taken place in the juvenile courts. And the juvenile magistrate is a kind, usually presided by a lady magistrate and taking care of the juvenile cases. The punishment is not given, rather they will be sent to the reformatory school or hostel schools. In special cases, like with different acts, the different special courts are there in prevention of the atrocities, acts for the scheduled tribes and scheduled castes. Then Essential Community Act also has got their special courts to look after any offense is being taken place. Narcotic, Drug and Psychotropic Substances Act, their illegal possession, illegal sales, if it is there, the special courts are taking care. Terrorism and Disruptive Acts is the TADA Act, which looks after this kind of activity. Prevention of Terrorism Act. Then Cases of Economic Offences and Corruptions Act. These are the special session courts there. So you can see the various magistrates and their powers. If it is a chief metropolitan, usually situated in the metropolitan area, cities, then they have got a power of 7 years imprisonment without fine, without the limit of fine. They can fine up to any amount. The chief judicial magistrate has got a jurisdiction and their court at a district place. 7 years imprisonment they can award. Again, the fine without limit will be awarded. The metropolitan magistrates are situated in the metropolitan area. 3 years of imprisonment can be awarded with 10,000 rupees limitation. The judicial magistrate of first class are usually situated at the subdivision of the district. 3 years imprisonment they can award with 10,000 fine. The second class judicial magistrate are again situated at the subdivision of the district. With 1 year imprisonment they can award, and 5,000 rupees fine can be awarded with this. So to summarize, the courts in India are of Supreme Court, High Court, Session Court and Magistrate Court type. What are the sentences prescribed by the law? It is the training, treatment and rehabilitation of the offenders as we discussed in the juvenile. Then the fine can be awarded as we have seen. The forfeiture of the property, then imprisonment, they will be sent behind the bar. It will be of simple kind or with some work, rigorous, or sometimes they will be imprisoned for the solitary confinement. It is nothing but they will be left alone in our custody. Imprisonment for life. There is misconception of 14 and 20 years. No, it is very specifically mentioned imprisonment for life means for life. Will be sent behind bar. And the capital punishment. Capital punishment is nothing but a death penalty. So what are the various ways of executing the capital punishment? You know, there are judicial hanging type. The person will be asked to sit in a electrical chair and electrocuted, will be injected with lethal drugs like sodium pentothal or pancuranium injections, or sometimes they will be decapitated with the guillotine. Also, garroting is one of the methods. Stoning, shooting are some of the examples. But in India, it is done by the judicial hanging. It is the capital punishment in India. Now coming to the offenses, there are two kinds of offenses, cognizable and non-cognizable. Cognizable offenses where the police officer can arrest the individual without the order of the magistrate, and it is of severe kind. See the examples. Ragging is the cognizable offenses. So with this platform, I appeal to every student not to get indulged into the ragging. Being a cognizable offense, you will be sent behind bar and your future will be very much in dark. So avoid the raggings. Rape, murder, dowry deaths are the another examples. Non-cognizable is of less severity. Police can't arrest the individuals without the orders of the magistrate. The examples are forgery, cheating, even pickpocketing, molestation, dacoity, snatching, extortion are the examples. For cognizables, we have already seen the homicides, murder, rape are some of the examples. How the witness will be called in a court of law? So by sending a document, by sending a letter, and that letter is called as a summon, that document is called as summon. It is also known with another name called as subpoena. So it is nothing but a document compelling the attendance of a witness in a court of law under penalty. If he fails to attend, penalty will be charged. So individual will be served with summons. What is this summons? Summons is the document. It has got name in whose name the summons is being sent. It will describes on which date the witness is expected to attend the court, the time, the place, which court specifically, and in which case the witness is being called is also mentioned along with the sections applied to that case. It is usually being signed by the officers presiding, and it has got a seal of that office. And accordingly, if you are getting the two summons at a time, so for the same date, then you should choose a criminal court for attending the evidence in that situation. If you are getting the two summons on the same date from the criminal court itself, then you should choose the place who has actually issued the summons at the earliest. So the first received summons will be given priority. If you fail to attend the court, it is your duty to inform the court regarding your inability. You might have posted your emergency operation there, but it is your duty to inform them regarding the medical services you have assigned. So the court will get convinced with your explanation. But if you fail to convey the court why you have not attended, you sometimes will be served with another summons. If you do it again, then you will be served with a bailable warrant in which you have to attend the court. If you fail to attend, you have to pay the penalties there, because the penalty will be taken while serving the summons itself. Again, if you make a mistake there, if you make a failure to attend the court, you will be served with non-bailable warrant, in which the police will come and will take you to the court of law for evidence purpose, and which is popularly known as arrest warrant. So subpoena or the summons is also of two kinds, in which it is very popularly known as subpoena ad testificandum, in which the witness is expected to give his testimony only in a court of law. But subpoena ducis tectum is the another kind of summons in which you are expected to bring out some document along with you while deposing the evidence in a court of law. You can see on a screen that in this case, it is very clearly stated that please bring the medical record of this case. So this kind of instructions will be served in a summons. In cases of civil cases, the doctor will be offered a fee to attend in a court of law while serving the summons. And this is what called as conduct money. But it is not being there in a criminal cases. If in a civil cases, doctor feels that that amount is not sufficient, he may ask it for the additional amount, but he will be given. But in criminal cases, he has to attend the court. He has to receive the certificate from the court that he has attended. And for the government employees, he can submit it to his office claiming for the travelers allowances. For the private doctors, they can claim for the court itself, and that can be given. So it was wrongly conveyed that the traveling expenses are not given by the court of law. It is given, but it is given while serving the summons itself in civil cases, while it will be given after your evidence in a court of law in cases of criminal cases. So what are the evidences? So under section 3 of the Indian Evidence Act, all information which the court permits and is helpful in the matter of fact under inquiry is considered to be the evidence. So evidences are of oral type and in which it is direct and indirect. Direct means the individual who has actually seen the incidents, seen the crime, seen the offense, and can first-hand knowledge, has capability to explain everything about the offense. This is called as oral evidence. Circumstantial evidence, here the individual has not seen, no one has seen, but the circumstances were like that so that the court can correlate the things. And that's why it is indirect type of evidence. Hearsay evidence, the individual who has heard something about the incidents but has not personally or individually seen the incidents. And that's why hearsay evidence is another one. Documentary, any documents will be counted as evidence until and unless it is accepted in a court of law. So for we doctors, all these medical evidences are there. In addition to this, in 2017, the judgment has been given, and that is the historical judgment that any video recording, any video clippings, audio clippings as an electronic evidence can be considered, provided its authenticity is considered well. It is proved beyond the doubt. So these are the various evidences. So for we doctors, the medical evidences are like medical certificates. It includes the death certificate, the certificate which is issued when the person is undergoing treatment, like sickness certificate, the medical fitness certificates. So these certificates will be considered as evidence, and you will be called to explain the facts about the certificates. So precaution is to be taken while issuing all those certificates. Medical legal reports like autopsy report, the examination of sexual offense cases, victims examination, the accused examination, the injury report, all those are the medical legal reports and also are the documentary evidences. Dying declaration is the additional medical related evidence. Dying deposition is another one. So what is this dying declaration? It is a statement written or oral made by a dying person as a result of unnatural cause. So in that situation, the statement of that dying person is taken. Such case, if it is hospitalized, it is duty of the treating doctor to inform the police and to the magistrate to reach to the hospital for statement purpose. If the police officer or the magistrate is not reaching within the time, then even doctor has got a right to take the statements. Usually it is taken by the police officer, very well admitted in the court of law. The doctor's role here is to see the mental alertness and the individual's capability to understand the questions, and if he or she is aware about time, situation and place, then the certificate of composement is, or the case will be certified as composement is, and the process will start. It should be done ideally at the beginning, at the end. And here no investigating officer is expected, and after completing, the signature is taken and then it is submitted to the court of law. So this is dying declaration. If the person dies after this, it stands very well in a court and becomes strong evidence. But if the person survives, then person will be called in a court and cross-examined. So it has got no value after the person survives. Dying deposition, which is not practiced in India, is usually a mini trial taking place bedside. So here also the mental alertness of the dying person is tested. Investigating officer or magistrate will be present. As if the mini trial is taken place, the accused will also be present and is cross-examined. So with this, we will again continue with the topic there. So in this further continuation, what are the different types of the witnesses? Then how the recording of the evidence will be taking place in a court of law? What is the procedure after being called in a court of law? Then if you as a doctor will be called in a court of law, then what are the various measures, precautions, formalities you are supposed to follow as a doctor to be presenting yourself in a court of law will be discussed here. So types of witnesses, see the slide. Two main types of witnesses are there, common and expert. Common, any individual who has actually witnessed or seen or present at the incidents and has got a first-hand knowledge rule. First-hand knowledge, which is called as first-hand knowledge rule, so that after putting any questions, if he explains everything factually, is a common witness. He is not qualified in any of the specialty. So a common man may be called in a court of law, and with his common knowledge of his presence at that instance itself is making him as a common. Expert witness is a person expertised in various skills, in various specialty, so that he had acquired some knowledge, and on the basis of his skills, knowledge, he can opine scientifically, and that's why he is called as expert witness. Doctor comes under the expert witness category, being skilled and medically knowledgeable individuals. The other examples are handwriting expert, fingerprint experts, the engineers. All those are the types of or the examples of expert witness. These two are the main witnesses. If any witness, either common or expert, under the oath gives the false evidence in a court of law, called as hostile witness. So witnesses you can consider men as two, common and expert, but yes, hostile witnesses are also there. So doctor sometimes has seen the incidents, then he will be called as a common witness also. But doctor as an expert usually being called, it is there in everyone's life that at least once he or she as a doctor will be called in a court of law for deposing the evidence in the court of law. And under the oath, if doctor depose the evidence falsely, he may be considered hostile and may be penalized. So if sometimes the MCQ is asked, which kind of type of the doctor will be considered as a, which category the doctor belongs to amongst the category of witnesses. So any of the above. So common witness, expert witness, or even the hostile witness also. So the act of giving the falsehood utterance is the perjury. Under section 191 of the Indian Penal Code, this perjury is defined. and it is punishable, which is described under the section 193 of the Indian Penal Code. See, almost 7 years of imprisonment is there. This will be done with some intention or with some threat or for some monetary gain. The person will be uttering some false, and in a court of law, the proceeding starts with taking the oath. Every individual is supposed to take oath and then give his evidence in a court of law. The children below 12 years of age are exception for this rule. Those who are believing in God can take the oath in the name of God, that I will tell truth, whole truth, nothing but truth. Those who are atheists, not believing in God, can solemnly affirm that whatever they are going to tell will be telling truth. The examination in chief, or which is also called as direct examination, is the next step. It is usually being conducted by the lawyer who has summoned him. It is not necessarily the government lawyer or public prosecutor will be starting chief examination. No. Prosecution witness is the witness in cases of crimes. Doctor, if it is called, will be prosecution witness, and in which the calling lawyer is the public prosecutor. And sometimes the defense lawyer can also call a witness, which is called as defense witness. The chief examination will be done by the defense lawyer in that case. He will try to collect as much as information in his favor by putting many more questions, but except the leading questions. Leading questions are the questions which has got yes or no answers, because it itself leads the witness to answer. So those type of questions won't be put. Cross-examination. It is considered to be the important part of any medical personnel who is giving his or her evidence in a court of law. Cross-examination in those cases will be conducted by the lawyer of the opposite party. If you will be called, the defense lawyer will be taking. So he will be irritating you, embarrassing you, and humiliating you. It is you to keep cool and calm, listen the questions quietly, answer within the frame of your scientific knowledge, and stick up to the records, what you have produced, what you have already submitted. Leading questions in this part of the examination is considered. Even it will goes on for hours together, days together sometimes. And it is considered to be the double-edged sword for the defense lawyer. Sometimes it itself brings out some of the points against him, so that which will further weaken the case. And if some of the doubts and the points are raised during the cross-examination, the lawyer who has called the witness will request the court for the re-examination, which is also called as redirect examination. It will be again done by the same lawyer who has summoned him, just to correct, clarify, and to add some details which were added later on after the cross-examination. Here again, the no leading questions are put. Then it has got a part called court question, or the question by the judge. Judge has got a right to interrupt the examination of the witness at any point of time to clear his doubt. So at any point of time, the questions will be put to just clear the doubts. See, one case of anaphylactic shock is there, which was actually being after the penicillin injection. Everything was taken, chief examination, cross-examination, and if the court has got a question that doctor, they can put to the doctor, doctor, is it necessary to test such a drug for the hypersensitivity test? That is the kind of questions the court can ask. So that will again add the information in the investigation or in the trial of that case. So at your screen, you can see for the undergraduate students, this may come as a long question to explain the method of recording of evidence in the court of law. These are the stages you are expected to write. I'm sure not only the undergraduate, but the postgraduate and the PG aspirants will also get benefited with, will be getting benefited with these online series of lectures. So I request all of you to attend it. Whenever the doctor is being summoned there in a court of law, you have got lots of responsibility because you are going to give the evidence which will determine the fate of the case, which will either give or deny the justice to the sufferer, the victim. So it is your responsibility. And for we forensic expert, this is the most important time where we will be called in a court of law in criminal cases, where our judgment is very crucial and we should stick up with the findings scientifically, and we should be giving our evidence in a scientific limits. So whenever summons is served, just find out which case is there. You have to prepare accordingly. Get all the aspect of that case from your records. You are expected to carry all those things with you whenever you reach. Be decent in your look, be well dressed, reach in time there, so that because of you, the trial should not start late. You are expected to meet there to the public prosecutor if the criminal case is there, discussed with him with all the details. You are not expected to discuss with anyone else. You should attend the court, you should enter the court with the permission of the court, and whenever the honorable judge is coming to preside, you should get up from, you should raise from your seat. And whenever you will be addressing to the honorable court, you should say, Honorable Sir or Sir, and keep your gestures a decent one, keep yourself cool and calm. Yes, there are chances that as you are attending it for the first time, there are chances that you may get nervous, you may get stressed, but it is you to control yourself. Your cool and calm presentation will be putting the defense lawyer in problems. Your good sort of answering will be putting the defense lawyer in much problems. Then you are expected to answer within the limits of your scientific knowledge. Stick up to the record. Whatever information is given in the record, only you are expected to tell.